Hi, everybody. Okay, so this week is all about how a case goes from here to through the system. Okay. And the reason why it's important to know about the process of a case is because one day you will, not might, but you will have to walk through those courthouse doors and give testimony, provide information, serve as a witness, justify something you wrote. So it's extremely important to have that knowledge in place so that way sorry, so that way you know what you're walking into and why you are serving in the capacity that you are, right? So without further ado, we're going to talk about the structure of the courts. Now, you should be wondering, wait, what court is this, right? So we are part of a circuit, meaning Texas, Louisiana. We're part of what's called the Fifth Circuit. And if you lose at a federal district court, you appeal to here. This is where you would go. It's in New Orleans, and it is a beautiful building that is a hop, skip away from Bourbon Street. So I actually used to study in this building when I was in law school. Because when I was in law school, most of the books were not online. They were actually still hardback books. So when I had to look up a case, I had to go look in a book. And I used to love studying here because afterwards, my friends and I would leave. And then what did we do? Go get Bloody Marys. Good study structure. I'm kidding. But if you ever go to New Orleans, definitely check out the Fifth Circuit because it's a beautiful building. And it's where most cases go and end. Most cases do not end in the United States Supreme Court. So this is the place to be. Now, on to the moral of this week's theme, which is structure. It's all about structure. So in order for a court to even hear a case, they have to have proper jurisdiction. And you may hear that term a lot. You hear it in movies, shows, books. It surrounds us. But you have to ask, what does it mean? So jurisdiction is the power of the court to hear and decide a case. So in order to determine whether or not a court does or does not have proper jurisdiction, you have to determine what type of case are you looking at. So you have to determine, is it criminal or is it civil? So here's the difference. You guys probably all rent right now, whether you're renting an apartment or in a dorm or a house, you're renting a house, whatever the situation is. If you broke your lease and they come after you, you're not going to go to jail. Okay, that's the good news. So you won't go to jail because it's not a crime to break a lease. Rather, it's a civil offense, which means the only punishment that you might be allocated is a fine, money. So the outcome of a civil trial is never going to be incarceration, ever. It's going to be money, a fine. Okay, so you have to determine, are we dealing with a crime or are we dealing with a civil offense? After that, you have to ask, is this a state crime or a federal crime? And in order to determine that, you have to say, is this a federal violation? Meaning, did you go to the national seashore and shoot a whooping crane, which is endangered? If you did, that's a federal crime because you've just violated the Federal Endangered Species Act. But is it a state crime? No, it's a federal crime. So if you shot a whooping crane, you go down the federal court route. But if you shot somebody, let's say you got pissed off at your neighbor and they threw a Whataburger cup in your yard and you're like, and you lose it and you shoot them, that's a state crime. It's a state crime to murder somebody, right? Because you victimized the state, your community. So second, you have to determine, well, where did it happen? And that is the state where the event, the crime at issue happened. So if I steal a car in Texas, could the case be brought in New Mexico? No, because New Mexico has nothing to do with it. So jurisdiction is based on criminal or civil, state or federal, and what state did it even happen in, right? The second thing you have to look at is venue. So venue, and let me move my head a little bit so you can see, there you go. The proper definition, but as you read the proper definition, listen to me when I say, basically it's what county did it happen? So where in what county? Nueces County. So if I drop a piano on somebody's head on purpose, here in Corpus, I will be heard, the venue, the court that will hear it is a criminal court in Nueces County. Why? Because it happened here. So jurisdiction is what type of court hears the case and what state, whereas venue is it's a more micro look. It says, what county did it happen in? Okay, so you have to make sure that you have proper jurisdiction and proper venue before you decide whether or not a court is or is not the proper place to hear the case. So how many venue options would Texas have? If it's based on county, how many venue options are in Texas? Well, how many counties are in Texas? 254 venue options. Everything's bigger in Texas, right? So you have 254 venue options here in the great state of Texas. Now, this is kind of a dated map. I apologize, but I wanted to show you something. Well, no, I shouldn't say every, but a lot of law firms have this specific map that'll look similar to this. And it's typically for defense attorneys. Defense attorneys will look at this map, and what they're looking at is here it says this color-coded map indicates the best judgment as to potential exposure level of the individual counties from most to least favorable to the defense. So the defense wants to know for their client who committed X crime and this specific county, whether or not the court is going to most likely rule in their favor, or is the court most likely to rule against them? And you see it's even color-coded. It says it's distinguishedly unfavorable and South Texas on the border for defendants, right? Whereas it looks like it's pretty favorable in little pockets of Texas. And then it goes to favorable to neutral. And it looks like Nueces would be neutral, right? So they look at this map to determine whether or not the venue, meaning the county, is or is not favorable to their client. So let's take an example. If Bill Murray, who lives and works in LA, California, runs over and kills a jaywalker in San Marcos, Texas, what state court has jurisdiction over the case? And the trial is likely to be held in what county? Well, it would be a criminal state court has jurisdiction here in Texas, and the trial is likely held in what county? Well, San Marcos is in Hays County, so it'd be in Hays County. That would be the venue. So remember, jurisdiction is where you ask whether the case at issue is criminal or civil, is it a federal or state crime, and what city or county did the crime occur? But remember the Sixth Amendment. We have these beautiful amendments. Remember, the United States Constitution would not have come to fruition if it weren't for our founding fathers promising that they'd give the people rights 3 years after the original Constitution in the form of Bill of Rights amendments. The Sixth Amendment guarantees all of us the right to a speedy and public trial by an impartial jury of the state and district wherein the crime shall have been committed. That means that if you commit a crime in Nueces County, you're going to get a jury of Nueces County citizens that will serve on your jury to hear the facts of the alleged crime that you're being charged with. But you can change venue. If such prejudice prevails in the county where the case is to be tried, that the defendant cannot obtain a fair or impartial trial. So what if I went cuckoo for Cocoa Puffs here in Corpus and I start killing puppies? I'm like, woo, down puppies, blah, 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 blah. And that's how I'd kill puppies, guys. I would never do that. But I start killing puppies and I'm killing kittens and I'm going into everybody's yard here in Corpus and I'm just going crazy. Would I get an impartial jury if I am heard here in Nueces County? Probably not, because probably in Nueces County, everybody knows me as the infamous puppy killer, right? So I could request a change of venue because such prejudice prevails in Nueces County that my case would not be heard by an impartial jury. The other reason why you can have your venue location changed, meaning the county in which your case is being heard changed, is if there's just a better place. And I'll give you an example. When I practiced law in Louisiana, we had a case in which the counties in Louisiana are not called counties, they're called parishes because everything's different in Louisiana. And they did something really interesting when they created the parishes in Louisiana. Some of them are the same parish name, but they're in completely different spots, right? I know, very weird. But we had a case in which the crime happened in Jefferson Parish, but the courthouse was in basically this region of the state, and everybody lived in this part of Jefferson Parish toward the bottom of the state. So it was very inconvenient for them to go all the way up here when they lived in a region in which they literally didn't own a car. All they had was a pirogue. Do you know what a pirogue is? It's a little boat. So we requested a change of venue based on the fact that it was just easier to have it in a different county that was actually closer to them than their actual parish county's courthouse. Weird, right? So you're probably wondering, why is our professor talking about this? Well, I want you to study this for your discussion this week, James Holmes. So many years ago, James Holmes entered a movie theater dressed as the Joker and shot multiple people dead, right? And so the question was, his attorney was trying to get his venue changed away from Aurora, Colorado, because he argued that basically so many people had been touched, affected by his crime, that he would not have a jury, an impartial jury, for his trial. And the question is, do you think the decision to keep Holmes' trial in the county in which the shooting took place was a good one or a bad one? Did it matter? That's what you have to dissect for this week. All right. So, you know the saying, if it's not broke, don't fix it. That is very true when you think about state and federal court. They're very much the same, meaning both are hierarchical, meaning you go from the lowest court all the way up to the highest court. So they both have a hierarchy structure. The trial court has what's called original jurisdiction. That means that case is being heard for the first time in that courtroom, trial court. No other court has heard it. No other court has ruled on it. So it has original jurisdiction, meaning they're hearing it for the very first time. The second court in both the state and federal court system is the appellate court. This court just reviews the lower court's decision. Then at the top of that pyramid, the pyramid structure, you have the Supreme Court, which determines what the law is. They have the final say so, thanks to judicial review, remember? Both of them have the similar decision-making authority, meaning the judge makes the legal decisions. They determine whether or not first-degree murder was properly asserted in the case, for example. Whereas the jury, they're called the fact finders. They don't determine whether or not first-degree murder should have been charged as opposed to second. That's not their wheelhouse. Their job is to determine, did Bob enter Whataburger at 2 a.m. on a Wednesday and open fire on the employees? So they determine the facts, whether or not the facts did or did not occur based on the information that they're told throughout the trial. So let's look at the structure in a different way. So here we're looking at the United States Supreme Court, and this is federal, the federal line. Okay, we're looking at the federal line. So if you shot a whooping crane, this is where you would go, right? So you have the federal process, which is you go first to the United States District Court. The court has original jurisdiction because they haven't heard about you shooting that whooping crane yet. This is the first case to hear that. If you lose and you appeal, you will appeal to the United States Court of Appeals Circuit Court. And here we would go to the Fifth Circuit in New Orleans. If you lose there, you can appeal to the Supreme Court, okay? Now, what if you murder a bunch of people at Whataburger? You would start out at trial court. That's just like the district court. Both of these, the district court and the trial court, have original jurisdiction. If you lose there, you can appeal to the state appellate court. If you lose there, you go to the state Supreme Court. And if you lose there, of course, you can appeal to the United States Supreme Court. So you see how similar they are? Very, very similar. Now, trial court, you have 254 options, okay, in the state of Texas. In the state of Texas, though, you only have 4 district courts, which are divided by north, east, west, and south. If you lose there and you go to the appellate court in the federal system, you have 13 circuits in the country that your case can go to. But again, we're in the Fifth Circuit, so we only have one option. If you lose at the district court, you will go to the Fifth Circuit. Now let's focus a little more on the federal process. Every state has one. Every state has a district court or more. We have more because, again, Texas is big. The judges are appointed for life. Okay, they're not going anywhere. And this is important. The founding fathers instituted that in Article 3, because if, let's say, judges were elected every 2 years, what might they be prone to do? Well, they may be prone to ruling in a certain way to ensure that they will appease their constituents. So they'll get hired again, elected again. And the founding fathers didn't want that pressure, or that influence. So instead, they said they're there for life. So that way, they're not going to worry that if they rule this way as opposed to this way, they won't get elected again, because that's not an issue. They're there. Their booties are on that bench for life. Now, here is the federal district courts in Texas. Remember, the district court, if you commit a federal crime like shooting a whooping crane, you're going to be heard here in one of these 4 districts. And it depends on where you shot them. Here, we said you shot at the National Seashore, which would be here in the purple, right? Which is the Southern District Court. So you have 4 options, district options in the federal court system, depending on where you committed the deed. Now, if you lose at the district court level, you can appeal to the 5th Circuit. Now, this is not mandatory, meaning judges cannot and will not automatically accept your appeal. It's discretionary, okay? So the decisions of the courts of appeal are final, except that they're subject to discretionary review or appeal in the United States Supreme Court. So if you lose at the 5th Circuit and you try to appeal it to the United States Supreme Court, they don't have to hear it. So typically cases die at this level, at the 5th Circuit level. But again, the 5th Circuit doesn't even have to accept your appeal. That's really important to note. Now, the United States is divided into 13 circuits, and you see that Texas, Louisiana, Mississippi, we're all in Circuit 5, meaning if you lose at the district court level and you appeal it, your case will be heard in the 5th Circuit. Now, for appellate court judges, they're also there for life, and they hear cases in panels. Now, what that means, guys, is that you do not have a jury, meaning I argued a case before the 5th Circuit, and you don't have a jury. You have a panel. It's very Harry Potter-esque. You have a panel of judges, typically 3 judges that sit together, and they hear your case, and they will pepper you with questions like crazy, right? And you got to be on your A game because they're going to ask you some doozies. So they hear the case in panels to determine whether or not the law was properly applied and by the district court. If you lose there and you appeal to the United States Supreme Court, that's it. Game over. This is the court of last resort. There's no other case or, court above and beyond them. There are 8 justices and 1 chief justice, all serving life terms. So who is our current chief justice? Do y'all know? If you email me by Sunday, I will add 2 points onto your quiz score for this week. So do it. So who's the current chief justice? Now, they determine whether or not to accept or reject a case based on the writ of certiorari. A writ of certiorari is a fancy word for it's your request saying, please, Supreme Court, please hear my case. May you hear it? And very few are actually accepted. This last year, less than 1% of cases that were submitted to the Supreme Court were accepted. So I'm going to say that again. Less than 1% of cases that were submitted to the Supreme Court were accepted for review. So what does that mean? It means that most cases die at the circuit court level. And if you want to see what oral arguments are coming up or what's on the pipeline for the United States Supreme Court to hear, go to this calendar. Now here, they're also serving for life. Supreme Court justices are there for good, right? It's nearly impossible for a Supreme Court justice to get booted off the bench. In fact, it's never happened in history. It almost happened. Remember when I described John Adams and Jefferson's contentious presidential election? Well, when Jefferson came in, remember, he was not a happy camper with Adams, who flooded the courts with Federalists. And so one of the Federalists who was a supporter of Adams was on the Supreme Court, and he kicked him off. But then the Senate came back in and said, Jefferson, we're sorry, but you kind of can't do that. So they put him back on. So even the very one time that one Supreme Court justice was kicked off, they came back. So technically, no one's ever been permanently banned from or taken away from their office at the Supreme Court. And that's him. He was like, you can't get rid of me, Jefferson. All right, so quick recap. Federal and state system are both hierarchical. Both have jurisdiction and venue options that you have to consider. Federal cases go from district court. In a state case, you start at trial court. From district court, you go to a circuit court, meaning Fifth Circuit. Whereas with the trial court, you go to the appellate court. If you lose in federal court, at the Fifth Circuit, you can appeal it to the Supreme Court. And if you lose the appellate court level, in a state case, you can go to the state Supreme Court and then the United States Supreme Court. So there's one extra step, arguably, in the state case process. Now, I highly suggest that in this week's module, you try to fill out that handout I gave you without looking at this to see if you can write out the process without referring to your notes. And if you can't, practice until you're able to. So now we progress to pretrial proceedings, but specifically, we focus on the progress of a felony. Now, you as criminal justice majors need to know what a felony is. These are the serious crimes. These are crimes that are punishable by death, imprisonment in excess of 1 year. So you're going to be in prison if you are convicted of a felony. If it's 1 year or less and not punishable by death, it's a misdemeanor. So we are going to focus this next week on that. Let me stop here. So revisit your notes, focus on the process between a federal case and a state case, and see if you can fill out the handout that I created in this week's module. Again, if you have any questions, if you need any help, absolutely call, text me, send smoke signals, whatever is easiest for you. I look forward to seeing what your thoughts are for this week's discussion, and I will talk to you next week. Adios.